Test. 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 1, 2. Hey Jeff, can you unmute your WebEx? Everything good? Can you talk into it?
Test.
Sounds good to me. It's working.
Good morning, it's 9:30, so we'll go ahead and get started. My name is Suzanne Bond, and I'm here on behalf of the Illinois State Police. We are pleased to offer 3 public hearings regarding ISP's proposed rules pursuant to the Protect Illinois Communities Act, and we thank you for coming today. ISP is committed to fulfilling the duties and responsibilities the legislature has set forth for the ISP in the Act. ISP has developed and implemented a public notice and public outreach campaign to promote awareness and the provisions of the Act about the provisions of the Act, and published several different resources on its website to help people understand and comply with the Act. For example, our website has links to the Act, to the department's proposed rules, and a PICA identification guide, as well as numerous FAQs. Additionally, ISP has posted routinely on its social media channels about the requirements under the Act, and produced a tutorial video to help guide the public when disclosing assault weapons, assault weapon attachments, 50 caliber rifles, and 50 caliber BMG cartridges as defined by PICA. The PICA identification guide is intended to assist Illinois residents with determining whether they have an assault weapon regulated by the Act. To the extent they do, we remind them to use our website to submit their electronic endorsement affidavit prior to January 1st, 2024. The FAQs are intended to provide additional residents can comply. ISP has made every endeavor to ensure our administrative rules are within the authority set forth in the statute by the legislature. These hearings are held to gather your questions and ensure we have addressed them within the limits of our authority before we move to second notice in the Joint Committee on Administrative Rules process. The public comments we have received for the hearing today will now be read, and then we will acknowledge those individuals who submitted witness slips to speak at today's hearing. As a reminder, per the public notice, if you did not submit a witness slip in advance, you will not be permitted to speak today. However, the ISP will be accepting written comments until November 20th as part of the first notice process for its proposed rules. Please remember your remarks are limited to 3 minutes. People speaking on behalf of a group or organization or their constituents will be permitted 9 minutes. If a question is posed today and ISP has already answered the question, I will read the FAQ and the response to the question. Today's meeting is being streamed and recorded. Okay, next we're going to do the reading of the public comments that were submitted ahead of time. These comments do not reflect the views or opinions of the ISP, but rather are being read verbatim into the record as a part of this public hearing. To the extent that questions were submitted as written comments, they will be read into the record, answered to the extent possible today, and addressed further during the first notice process where necessary. Okay, go ahead.
The first public comment is from Alex First. rural towns that have their own maze of traps. Registration schemes are illegal, aren't they? Why worry? Well, mandatory registration may lead to equating lawful firearm owners with registered sex offenders, and history has shown that lists can easily be hacked and abused by Democrats, rabid gun control zealots, the media, and other mean-spirited people or groups. Who will ensure that registration files are 100% safeguarded? No one, because Illinois wants to inflict harm and inconvenience on every firearm owner. Ask yourselves, when Israel's were attacked by terrorists, why did their government keep them disarmed for days? How many lives could have been saved if Israel's citizens could have fought back against terrorists? With America's borders wide open to unvetted persons from countries who hate America, why does Illinois insist on shackling the hands of people who could become first responders against terror, gangbangers, whack jobs, and home invasions? In conclusion, the ISP cannot keep us all safe from evil. The PICA law and its slippery slope of vague rules unfairly treat law-abiding citizens as felons. Illinois should rethink how much money will be wasted going to court in the face of Bruin and other case law from the Supreme Court. That money could be used to shore up mental health treatments and body armor should law enforcement ever seek to disarm the actual criminals who are ruining lives in Illinois. Next public comment is from Oliver Haynold. In 9 months of attempting to give PICA meaning, the state police found itself unable or unwilling to come up with any guidance that In 9 months of attempting to give PICA meaning, the state police found itself unable or unwilling to come up with any guidance what exactly an assault weapon attachment would be. The proposed amendments contain nothing to the effect, and the FAQ on the state police's website conscientiously punts the question. What assault weapon attachments regulated under PICA? With the non-answer, please refer to section 720 ILCS 5-24-1.983 within the link above. Citizens cannot be expected to find meaning in PICA where the state police cannot. The definition of assault weapon attachment in PICA reads, any device capable of being attached to a firearm that is specifically designed for making or converting a firearm into any of the firearms listed in paragraph 1 of this subsection A. This can mean all or nothing. I would like to illustrate this vagueness and potentially endless reach with a few examples emanating from a simple and cheap plastic part, a grip. Is a pistol grip that fits an AR-15 style rifle and assault weapon attachment. PICA specifically mentions a pistol grip as a part of an assault weapon, so this question is certainly more complicated than the common sense answer that the grip is a harmless piece of plastic.
Yes, a grip is an assault weapon attachment. Answers to these questions can be found on the State Police website on the Protect Illinois Communities Act page. Specifically, please see FAQ number 11. Please provide examples of things that would be considered an assault weapon attachment. The list below is intended to be illustrative and not exhaustive. Pistol grip or thumb full stock. Any feature capable of functioning as a protruding grip that can be held by the non-trigger hand. A folding, telescoping thumb hole or detachable stock, or a stock that is otherwise foldable or adjustable in a manner that operates to reduce the length, size, or any other dimension or otherwise enhances the concealability of the weapon. A flash suppressor, a grenade launcher, a shroud attached to the barrel or that partially or completely encircles the barrel, allowing the bearer to hold the firearm with the non-trigger hand without being burned, but excluding a slide that encloses the barrel. A threaded barrel, and a buffer tube, arm brace, or other part that protrudes horizontally behind the pistol grip and is designed to redesigned to allow or facilitate a firearm to be fired from the shoulder.
Is a pistol grip that fits an AR-15 style rifle an assault weapon attachment when it is installed on a bolt action rifle that is indubitably not an assault weapon? The use of grips designed for AR-15 style rifles on bolt action rifles is indeed common. What if one swaps grips between an assault weapon and a non-assault weapon?
Yes, a pistol grip is an assault weapon attachment. Again, we refer you to the Illinois State Police website and FAQ number 11.
Is a safety detent spring that goes into a pistol grip that fits an AR-15 style rifle an assault weapon attachment?
No,
Is a pistol grip screw that is specifically marketed for affixing a pistol grip to an AR-15 style rifle an assault weapon attachment?
no,
Is an AR-15 vice block that holds the lower receiver of an AR-15 style rifle in place while one installs, for an example, a pistol grip, an assault weapon attachment. The vice block clearly attaches to the rifle for the purpose of making such a rifle, and it is specifically designed for this purpose. This seems to meet the language of the PICA as much as any other part.
no. The ISP does not believe that that is an assault weapon attachment.
Similar questions as with the grip arise with every other part of a rifle. Many hobbyists will have hundreds of potential assault weapon attachments in their tool chests and parts bin or installed on the non-assault weapons with no guidance which of these need to be declared. Even leaving the obvious constitutional infirmities of PICA aside, if Illinoisans are supposed to declare their assault weapon attachments, they deserve at least some minimal guidance what to declare. Any serious attempt at giving such an answer could only yield one answer. PICA itself is impossibly vague. This vagueness should not be dumped on law-abiding citizens to take a guess on pain of a felony conviction if a court later disagrees.
The ISP has provided examples of things that would be considered an assault weapon attachment in its FAQs. Further amendments to the ISP's proposed rules are currently under consideration. The ISP is committed to helping the public understand the endorsement affidavit provisions and will accept an endorsement affidavit for an item even if it does not meet the literal statutory definition of an assault weapon attachment.
The next comments that were submitted were by Steve Monchonsky. 1. The barrel shroud language. Is a ranch model Mini 14 and 1022 legal? 2. Readily convertible magazines. The statute bans magazines that are readily convertible to high capacity. What does this mean? Is the 1022 okay because the handguard is part of the stock? What about something like a Kel-Tec RDBC or a handmade handguard for a Fight Light SCR receiver? We need clarification, not just on what guns are fine, but why they're fine and other aren't.
Answers to these questions can be found on the ISP website on the Protect Illinois Communities Act page. Specifically, we would direct you to FAQ number 8. Is a forestock considered a barrel shroud and therefore regulated by PICA? The answer is no. A shroud is not an integral component of the stock, but rather a separate piece. For example, the wooden forestock on a base model Ruger 1022 does not constitute a shroud. Please see the ISP's PICA guide. Other examples of forestocks not constituting shrouds would be the base model M1 Carbine, M1 Garand, and Savage Model 850, assuming they have no other features regulated by PICA and have not been modified to include any regulated features or attachments.
What parts are we legally allowed to purchase in the event one of our weapons break or we lose a trigger spring or a pin on a grandfather gun?
Again, we would refer you to the Illinois State Police FAQs, specifically number 41. If an Illinois resident has an AR-15 or assault weapon prior to the passage of this act, where can they legally possess the... Oh, wait, I apologize. I think I'm on the wrong. No, I'm on the right one. Sorry. Where they can legally possess the firearm. After April 10th, 2023, an Illinois resident can legally possess the firearm on private property owned or immediately controlled by the person on private property that is not open to the public with express permission of the person who owns or immediately controls such property while on the premises of a licensed firearm dealer or gunsmith for lawful repair, at a licensed firing range or sports shooting competition venue, or while traveling to and from these locations.
What is the definition of a flash suppressor? Is a muzzle brake included in this as well? There are two items with two different functions, but there's no guarantee they know the difference. Flash suppressor to mean all muzzle devices. An example for this is an M1A legal if the flash suppressor is swapped out for a muzzle brake. Does the MA plastic barrel cover count as a barrel shroud? The law and the ISP examples conflicts.
Again, I would direct you to the Illinois State Police FAQs on its website, specifically see FAQ number 9. Is a muzzle brake considered a flash suppressor and therefore regulated by PICA? While both are barrel attachments, they serve different purposes. A flash suppressor is designed to reduce the muzzle flash of the firearm. On military firearms, this is to prevent distant opponents from seeing where someone may be shooting from. A muzzle brake directs the energy of the muzzle blast in a specified direction in order to reduce the felt recoil of the discharge of the firearm or to prevent the muzzle from jumping during shooting. Most muzzle brakes do nothing to reduce the flash, and the specified one produced by Springfield has been ruled by the ATF to not be a flash suppressor.
What is the policy of the state police with regard to investigation and identification of PICA categorized firearm purchase between the April 28th injunction and the ensuing stay issued on?
Again, I am going to refer you to the state police website, FAQs, see FAQ number 16. How will this law be enforced? Law enforcement agencies, including the ISP, are charged with enforcing the Protect Illinois Community Act through the state. ISP will continue to enforce the Firearms Owner Identification Card Act and Article 24 of the Criminal Code of 2012 by partnering with local law enforcement through our Violent Crimes Intelligence Task Force. The task force is a collaborative effort to reduce and prevent illegal possession and use of firearms, firearm-related homicides, and other violent crimes.
What is the policy of the state police with regard to the 99.9% of owners of PICA categorized firearms who have historically been fully compliant with firearm laws that simply didn't capitulate to a registration which they are reasonably likely to be unaware of?
Again, this question, the answer to this question can be found on our website. It is FAQ number 16, which I just read before.
Please describe how the registration above is compliant with Title 18 U.S. Code and the Firearm Protection Act of 1986.
FAQ number 33 on the ISP website answers this question. How is the Firearm Owner Protection Act of 1986 relevant to ISP rulemaking under PICA? The answer to that question is it isn't. 18 U.S.C. Section 926 applies to the Attorney General of the United States and sets forth what rules and regulations a federal agency may create to regulate firearms. The authority for PICA and the endorsement affidavit is based upon a statute passed by the Illinois legislature and is not a rule or regulation created by a federal agency. See National Shooting Sports Foundation Incorporated versus Jones, 405 U.S. Appellate, D.C. 18, 2013.
What logic requires a citizen, after having completed a multi-month process of applying and receiving a FOID, who can now be instantly and digitally identified to have previously purchased firearms, open parent, 10-year FOID extension, closed parent, to wait 3 days to receive any new firearm after purchase?
This question does not pertain to the provisions of PICA, and it will not be answered today.
Please describe how the digital record of purchase is compliant with Title 18 U.S. Code and the FOPA 1986.
Again, the answer to this question can be found at FAQ number 33, which I just read.
The next public comments will be read by Robert L. Williams. Gun registration has long been a topic of debate in the realm of firearm legislation. While proponents argue that it enhances public safety and aids law enforcement, critics have raised valid concerns about its potential negative consequences. My statement aims to explore the diverse aspects of gun registration, focusing on 2 key points: how it can turn law-abiding citizens into criminals, and how it may violate the oath taken to uphold the Constitution. One of the most significant concerns surrounding gun registration is the potential to inadvertently criminalize law-abiding citizens. By requiring individuals to register their firearms, authorities create a situation where otherwise law-abiding citizens can unknowingly become criminals simply due to administrative oversights or bureaucratic errors. For instance, individuals who fail to update their registration after moving to a new address or inadvertently miss a deadline could find themselves in violation of the law without any criminal intent. Moreover, gun registration systems can be susceptible to data breaches or unauthorized access, potentially exposing law-abiding individuals to identity theft or unwarranted targeting. The misuse or mishandling of registration data also raises concern about privacy and can create a chilling effect, discouraging law-abiding citizens from exercising their constitutional rights due to fears of government surveillance or interference. Another negative aspect of gun registration is its potential to violate. Another negative aspect of gun registration is its potential violation of the oath taken by public officials to uphold the Constitution. The Second Amendment of the United States Constitution guarantees the right to bear arms, and any legislation that infringes upon this right could be seen as violating the oath sworn by those in positions of power. Gun registration schemes, particularly those that impose onerous requirements on restrictions, can be seen as undermining the fundamental principles enshrined within the Constitution. Additionally, critics argue that gun registration can pave the way for potential confiscation or stringent regulation of firearms, which would be an infringement on the rights of law-abiding citizens. History has shown that in some cases, registration has been a precursor to more drastic measures that erode the Second Amendment, leading to increased skepticism and concerns among gun owners. While gun registration proponents argue that it promotes public safety and assists law enforcement, it is crucial to consider the potential negative implications of such measures. Turning law-abiding citizens into criminals due to administrative errors or oversights undermines the fundamental principles of justice. Similarly, violating the oath to uphold the Constitution by imposing registration requirements that infringe upon citizens' Second Amendment rights raises legitimate concerns about the erosion of individual liberties. Striking a balance between public safety and the preservation of constitutional rights remains a complex challenge in the ongoing debate over gun registration. That concludes the public comments.
We'll now call people up one at a time for their in-person testimony. I would remind you that organizations are limited to 9 minutes and individuals are limited to 3. We will give you a reminder when your time is nearing the end. The first person invited to speak is Abraham Avalos on behalf of Illinois Gun Owners Together.
Guess having my name is Abraham Avalos is the consequence of me being called first. So I'm not only a member, so just to be on the record, I'm not speaking on behalf of Illinois Gun Owners Together. I'm just saying I'm just a member, but at the same time, I'm a member of other gun organization groups. And my comments, I would say, would go towards not only to the state police, but also to the director of Brendan Kelly as well. And correct me if I'm wrong, yesterday's hearing, the question was asked if this registration of firearms will lead to confiscation. And the answer was no. Am I correct on that? On yesterday's hearing?
The answer was the Illinois State Police has no intent to use the endorsement affidavit process to confiscate lawfully owned weapons.
Okay, so that answer applies as of today. So hypothetically, in the future, with the new state legislation session, what happens if they do pass a law to say to the Illinois State Police that certain firearms within the registration are now completely banned? You know, a particular AR-15 model because another shooting happens in the future. And they do pass a law, says that this particular firearms within the registration list are not banned, that you must confiscate. Now, will the state police, hypothetically, in the future, would go that route with a law being passed saying that?
Sir, it would be irresponsible of me to predict what the Illinois State Police would do in the absence of seeing legislation that specifically directed us.
So there's a possibility that it might lead to confiscation.
That isn't what I said.
I know, but my interpretation to your answer would be there is a possibility.
That isn't what I said, nor is it what I
know.
mean.
Okay. So the other thing is we have checks and balances in theory, and I'm here on the Google definition of checks and balances. It provides each government with individual powers to check the other branches of government to prevent any branch from becoming too powerful. Now, us gun owners would say that this law is unconstitutional. Now, the check and balance would be having this particular situation, having the courts looking at it to see if it's constitutional or not. So are you guys prepared to delay the registration and find out how the check and balances process work out and and to see what the court says, to see if it's constitutional? Are you guys willing to delay or to put a hold on this?
The Illinois State Police has no authority to delay enactment of the endorsement affidavit process. We have been directed to open it as of October 1st, and we have been directed that firearms, assault weapon attachments, 50 caliber rifles, and 50 caliber BMG cartridges are to be endorsed prior to January 1st, 2024. If a court were to issue a stay order, we would comply with the stay order. That has not occurred.
Okay, but the authority would become from the court when it happens.
Correct. As you pointed out, in our system of checks and balances, that action would have to come from the court. It could not come from an executive agency.
Gotcha. And my last comment would be, law enforcement has the discretion to do what they do. Obviously, you guys have the authority and power to do that. But I would encourage everyone in the law enforcement community to look at your oath of office, especially to the Constitution. There's a lot of things that gets passed through the state legislature and people are not happy. But it's a tough spot where you guys are at right now. And my comment would be just look to your oath of office and keep in mind you serve us. So when you're asking us to register our firearms, it's wrong. But you serve us, we don't serve you. That's all I have to say. Thank you.
Thank you for your comments today, sir. The next person invited to speak is Kathleen Sanchez on behalf of Gun Violence Prevention PAC. I apologize if I butchered your name.
No apologies necessary. Good morning, and thank you for this opportunity to make this statement. And I'd also like to thank the Illinois State Police and their entire staff and troopers for their service in keeping us safe every day. My name is Kathleen Sanchez, and I am the president and CEO of the Illinois Gun Violence Prevention PAC, better known as GPAC. We are the largest gun safety organization in the state, and I am here to double down and reiterate our support for the Protect Illinois Communities Act. Since this law was passed and signed into law, gun extremists in this state have waged a merciless disinformation campaign attempting to find new ways to water down this critical legislation or even to do away with it completely. But what we're losing sight of is what even made this law necessary in the first place. We are here because a man armed with a semi-automatic rifle decided to open fire on a crowd trying to enjoy their holiday. 7 people were killed, dozens more were injured, and this is one of the 2 deadliest mass shootings to take place in our state. Enough with the circular debates, the wasteful use of our court systems, and other tactics meant to appease egos and pockets. The law is needed, and it is necessary as is. We are not here to entertain the whims of the gun lobby and their supporters. We are here because we know that when laws like the Protect Illinois Community Act are not left to stand in their entirety, it is our lives and the lives of our children, friends, and neighbors who will be left unbalanced. We have seen the devastating consequences of gun violence in our communities and across this country. As we all join here together, the people of Lewistown, Maine are in agony over the rampage caused by a gunman who killed 18 people. Again, I say enough with any attempts to chisel away at a law that will save lives. Let public safety be something we can all get behind, and let it not be a matter that remains open for compromise. Thank you.
Thank you. Thank you for your remarks. The next witness invited to testify is Shreya Karup with the Students Demand Action Group. Again, my apologies if I mispronounced your name.
No worries.
Hello, hearing members. My name is Shreya Karup, and I'm a college student at the University of Illinois in Chicago. I am a Students Demand Action volunteer, which is a national grassroots organization with over 750 groups. First, I want to thank the members here for their efforts in implementing the critical and life-saving assault weapons ban that the legislature passed earlier this year. The Protect Illinois Communities Act legislative package was a huge step forward for the gun violence prevention movement in Illinois and across the country. And we are so grateful to the Illinois legislature and the state police for working to implement the prohibition on assault weapons in Illinois. We know that enforcement of these laws is critical to ensure effectiveness, and we are grateful to the Illinois State Police for proposing rules that will support the implementation of the Protect Illinois Community Act and ultimately help to save lives. We know that assault weapons are much deadlier than other firearms. While handguns account for more gun deaths every year than any other type of firearm, between 2015 and 2022, 8 of the 10 highest casualty mass shootings have been carried out with assault weapons, including the Las Vegas, Orlando, El Paso, Sutherland Springs, San Bernardino, Parkland, Dayton, and Uvalde shootings. In fact, over twice as many people are killed when mass shootings involve an assault weapon and or high-capacity magazines. Most recently, we saw the impact of these deadly weapons of war again in Maine, where a shooter, armed with an assault weapon, shot and killed 18 people and wounded many more. And let's not forget, in our own backyard, on July 4th in Highland Park, where 7 people were killed and 48 were wounded. As a college student, I am well aware of the consequences and the devastating impacts of weapons of war in civilian hands. I see so many shootings close to us every day. Just 4 days ago in North Lawndale, 15 minutes away from my campus, a semi-automatic weapon was used to shoot 15 people at a Halloween party. This year alone, we have seen at least 17 shootings occur at U.S. colleges and universities. I can truly say that policies like this help me feel safer on campus. The feeling of safety is a big thing for someone like me who is deemed to be a part of the lockdown generation. Policies like this are a step in the right direction, so there are no more generations like mine. Again, I want to thank you for allowing public comment on this, and I'm grateful for this state and helping to enforce laws to help save lives.
Thank you for your comments. The next person invited to speak will be Mr. Todd Vandermeide on behalf of Freedom's Steel.
Thank you, Ms. Vaughn. Member of State Police, Todd Vandermeide on behalf of Freedom Steel. I want to focus on just a couple aspects here this morning. Yesterday at the hearing in Springfield, it was said by the state police, magazine extension tubes are neither fixed or detachable magazines and not regulated by PICA. I would direct your attention to section 24-1.10. The issue isn't a fixed or detachable magazine in 1.10. It's large capacity ammunition feeding devices. And the statute says, they mean a magazine, belt, drum, feed strip, or similar device that has a capacity of, or that can be readily restored or converted to accept more than 10 rounds of ammunition for long guns and more than 15 rounds of ammunition for handguns. Part 2, any combination of parts from which the device described in paragraph 1 can be assembled. Your statement yesterday directly contradicts the black letter of the law. The law says if you have a combination of parts And this is an illustration of the types of magazine extension tubes that Mr. Sanders referenced in his comments yesterday, Mr. Witowski referenced yesterday in their comments. I would point out that your statement yesterday flies in the face of the state police's own submission to the federal court in the Southern District of Illinois. Here's a picture of parts. And as such, magazine tubes fall squarely within the combination of parts that can extend or convert, because the state police has offered no definition of readily restored, which means turned back to a condition it once was in, or converted to something it never was, but can be made into something different. How do you guys get around the black letter of the law?
The state police has indicated that it will take those comments under advisement and attempt to provide additional clarification in the proposed rules during the first notice process.
Well, since you haven't provided a definition, in the case of Vanderstock v. Garland, they argued in the Fifth Circuit Court of Appeals just a few weeks ago. The ATF, which I think we would all recognize as a very technical group when it comes to firearms, sat there and said that they submitted in briefs and footnotes that it's 8 hours of labor with a fully capable machine shop is the standard that they use to evaluate readily convertible or readily restored.
And that information was provided to us yesterday, and it is being taken under advisement and will be considered as part of our corrections or amendments to our proposed rules during this first notice process. We
Okay.
appreciate that input.
So let's get back to the shotguns that Mr. Witowski talked about yesterday. And let's particularly talk about the Remington 870. Those shotguns have a fixed magazine tube attached to the receiver. They're typically permanently mounted by, in the case of the 870 or the 1100, by silver soldering. So while 1.19 or 1.9 deals with an exemption for manually operated firearms, there's no such exemption in 1.10. And you cannot sell any magazine that can be converted. And by virtue of this, the Remington 870 pump action shotgun is illegal for sale in the state of Illinois because the magazine is permanently affixed and can be readily converted to. I can convert a Remington 870 in less than 5 minutes. Now, depending on whether or not you want to count the opening of the packaging for the extension tube in that. So again, I don't see in your clarification earlier today about parts, pistol grips. Thank you very much. You just told us that while there is no exemption under 1.10 for manually operated firearms, you just banned a whole style of pump action shotguns that are sold with AR-15 style pistol grips, AR-15 style stocks, AR-15 style buffer tubes. You just expanded the ban in here because 1.10 does not have an exemption for manually operated firearms with the exception of lever guns and tubular magazines for 22 rimfire ammunition. So I don't know how you're going to get around this. I think the black letter of the law is broader than the administration wants to admit to. And I think you have the same problem when it comes to the 1022. The black letter of the law says that it's anything, a barrel shroud attached to the barrel, or that's the law, as Mark Smith of Fort Diner says, the law that partially or completely encircles the barrel, allowing the bearer to hold the firearm with the non-trigger hand without being burned. It has no relevance to how it's attached to the gun. The black letter of the law that GPAC wrote bans the 1022. And if you look at the 1022 specifically, there is a barrel band around the standard traditional old walnut stock model that connects the barrel to the forehead. I don't see how you're going to get around this without a legislative change. And that's how I want to understand, how does the agency defy the black letter of the law?
State Police will propose rule to the Joint Committee on Administrative. And it will be up to that committee to determine whether or not the Illinois State Police has exceeded its statutory authority.
Okay, and I see that you quote the FAQs several times in your response to people, and thank you very much. But I have had the argument and discussion on the side of the road with your troopers about gun laws for being pulled over for a speeding infraction. Those FAQs aren't going to hold up when somebody is detained or questioned by a law enforcement officer. You can print those off all you want. And I've actually seen people hand parts of the law, not this law, but other ones, to law enforcement officers. They say, we don't care. You may beat the rap, you ain't going to beat the ride. And that's what I think you have a big problem here, because you haven't defined readily restored. You haven't defined readily convertible or what any of that means. And those are, legitimate areas for the state police and their rules to come down with something, just as the questions yesterday about what size shotgun shell is being used. It's not about the ammunition. I understand the act specifically does not regulate ammunition, but there has to be a benchmark, because as it was alluded to yesterday, I can fit way more shells using 1 3/4 inch minis into any one of my 12 gauge shotguns than I can if they're 3.5 inch shells. And what I think that the public is asking for is, what's the measuring stick we're supposed to use to find out if we are in compliance or we're not in compliance? I would also go so far is, I wonder which, since GPAC is all pride in their authorship, along with Mr. Morgan, I just wonder why they hate Star Wars so much. You see, this is a picture of Obi-Wan's lightsaber from the original Star Wars movie. And you know what they used to make that, the prop masters? They actually used a World War I No. 3 Mark I British rifle grenade launcher. They also used a flash hider and booster from an A&M 2 50 caliber Browning machine gun. So the question is, as a good law-abiding citizen and Star Wars fan, do I have to register my lightsaber? Because I actually have these parts.
It meets the definitions in the PCAP Act and it will be subject to regulation and the endorsement act.
So with that, I think your agency has been put into a position where it can't win, because a group of people who knew next to nothing about firearms or all the intricacies of all these things that they put into a law passed what they wanted with little thought to your agency. And I don't necessarily envy your position that you're in, because you've been handled a big pile of goo to try to fix, because the legislature isn't going to go about and do it. And I think you're in a catch-22 where you're damned if you do or damned if you don't. And, you know, thank you very much for your indulgence today.
For your comments. The next person invited to speak is Mr. Don Alworth, speaking on his own behalf.
Start.
Yes.
Hi, I'm Don Hayward. I own a firearms school in the city of Chicago. I've been around since 2008. I'm speaking individually.
Can you?
Yeah.
The mic. Thank you very much.
Since 2008, we've put about 210,000 people through our classes, all types of classes. We've not had one incident. And I'm not an extremist. Contrary, I'm a Vietnam vet, United States Marine. First thing I want to talk about is wardens. With Accuracy Firearms versus the governor and several other individuals, ISP is giving them or has given them an exemption for AR. Are you aware of this?
So the Illinois legislature included that exemption. The Illinois State Police did not add that exemption. It is a part of
There
the
is,
statute.
there is, but let me bring this up really fast.
Sure.
So in this lawsuit that I was able to read this morning, 240 pages, that was brought against the governor, et cetera, they have exempted wardens in Illinois for ARs. That's, they're allowed to carry ARs because of their experience. I must be on another planet because under the Freedom of Information Act, this law firm obtained training records on 102 wardens. Less than 8% had AR training, whereas the people involved in the lawsuit, all combat veterans, AR training. I'd ask you to review this lawsuit that is in the courts. Next, I'm a licensed private investigator. I've been one for years. There's some talk among my colleagues is that private detectives are being banned from 15-round magazines. Security people are not unlimited capacity because they do not think PIs need extended magazines, etc. And I don't know where in God's creation people come up with these ideas. Most of us carry service revolvers that have 15, 16, 17 rounds. But with the new law, PIs that also fall under the IDF PR statute with security people are banned from 15 rounds or more. And I'd like for you to take a look at that.
Certainly will.
And under the appellate decision, City of Chicago versus John Hayworth, me years ago, PIs are home rule exempt.
We'll make a note of that and review the litigation.
Yeah. My other question is PICA. What does PICA stand for?
Protect Illinois Communities Act.
Do you know who owns PICA? Who runs PICA?
PICA is a law, sir.
I understand that, but who backs that? I asked you to look into that.
Yes, sir. We've reached the conclusion of your 3 minutes. We do appreciate your time.
Okay, thank you.
Thank you for coming today. The next person invited to testify today is Mr. Kurt Wilcox. He is here on behalf of himself.
So first and foremost, I'd like to thank the Illinois State Police for holding these hearings. I thoroughly appreciate being heard as a member of the tax-paying public. The buzzword assault weapon has been a hot button topic nationwide and in the state, specifically after the Highland Park shooting, from which the Protect Illinois Communities Act saw its birth. The Protect Illinois Communities Act is no more than a draconian gun ban, a mandatory registration for those who already have them, and there is no outline to protect our communities at all. I've read it front and back, I've gone through it. There's no outline at all. Highland Park has had an assault weapon ban for years before the shooting. Chicago's had one for the last decade. July 17th, 2013, Chicago City Council passed their comprehensive assault weapon ban in a knee-jerk reaction to the statewide legislation to allow concealed carry. The comprehensive part of this effectively defining the term assault weapon and adding magazine capacity limits within Cook County. These bans and the gun laws that we have in place in Chicago has still left us with a gun violence rate 6 times higher than New York, 3 times higher than LA. Just last month in October, WTTW reported that Chicago officers have recovered 9,353 illegal firearms, including 967 assault weapons. That's 9,353 examples of the FOID card program not working, 967 examples of the assault weapon ban not working. The Protect Illinois Communities Act is doing the opposite. It's turning law-abiding citizens into felons while criminals continue to outgun the average citizen. Now, according to the Illinois Constitution, Article 7 regarding militia, the state militia consists of all able-bodied persons residing in the state except those exempted by law. The Protect Illinois Communities Act directly and negatively impacts the security of our state by effectively banning most of the weapons in common use. And they would be used to defend this beautiful state should the need arise. During the riots of 2020, the police were not responding to 911 calls. So my question is, How are those of us that don't own these weapons, are we supposed to protect ourselves, our families, our communities, should we see another summer of 2020?
Protect Illinois Community Act requires you to file an enforcement affidavit. It does not prohibit you from possessing weapons that you currently lawfully possess.
But it prevents everybody from buying them if they should feel the need, because I didn't own anything before. I didn't own a pistol beforehand. But it was the riots of 2020 when my city was under siege. The cops weren't coming to help us. The riots got within around the corner from my house. The stores that I go to every day were damaged and looted. There was no protection, except for the one store who had assault weapons, and they were not raided or looted or destroyed. Moving on, we currently sit at a 1% compliance rate. Less than 1%. So how does the Illinois State Police plan to deal with the other 2.5 million people armed with assault weapons and high-capacity feeding devices for non-compliance with only 3,000? With only 3,000 officers? That's a pretty big difference.
All Illinois law enforcement officers have the responsibility of enforcing the Protect Illinois Communities Act, not just Illinois State Troopers.
Now, does it violate the last line of the Illinois State Police Oath where you vow to uphold the country and state constitutions? And which constitution becomes before the other in that?
Certainly appreciate your remarks today. You've reached the time limit. Thank you for coming. Thank you for saying that.
Mike Dunn is not one of us.
That concludes the public hearing for the Protect Illinois Communities Act, Illinois State Police rulemaking. I would like to remind you that if you have comments that you wish for the Illinois State Police to take into consideration during its first notice period, those comments will be accepted until November 20th. There is an email address listed on our website, and we would welcome you to send comments. Your comments are being read, they are being considered, and where we can do so within our statutory authority, we will be addressing your comments through our public rulemaking. Thank you for your time.